So welcome, everybody. I'm Linda Conway, the Executive Director for New England Newspaper and Press Association. Thank you so much for joining us for our conversation today. And we're going to keep this as a conversation, so keep your camera on, turn it off, or whatever you feel like, whatever you're most comfortable with. David's gonna talk a little bit and open it up to conversation. So we'd like it to be as interactive as possible. We all get more out of it when we are interactive. If you want to ask any questions in the chat, if you feel more comfortable doing that, Tara will keep an eye on the chat. But let's say a warm welcome to David Enrich. David is the business investigations editor at the New York Times, and he's a best-selling author. Some of his previous books are Dark Towers and Servants of the Damned. He's the winner of numerous journalism awards. He previously was an editor and a reporter at the Wall Street Journal. His first book was The Spider Network, How a Math Genius and Gang of Scheming Bankers Pulled Off One of the Greatest Scams in History, and it was shortlisted for the Financial Times Business Book of the Year Award. He is a Massachusetts local. He grew up here in Lexington, and he now lives in New York. And today he's going to talk about the escalating threats to press freedom in our country, drawing on his latest book, Murder the Truth: Fear, the First Amendment, and a Secret Campaign to Protect the Powerful. So I'm going to turn it over to you. Thank you, David.
Hello. Thanks for having me. So it's obviously a small group, so we should just as far as I'm concerned, keep this super informal and casual. So if you guys have questions, just butt in. I was just gonna talk for a couple minutes at the outset about why I got interested in this topic. And yeah, as Linda said, I work at the New York Times. I run a small team of investigative reporters and do my own reporting and writing as well. And basically, my trajectory is kind of relevant to how I got involved in this topic. I had been at the Wall Street Journal for many years, and then in 2010, I think, moved to London with the Journal. And like a lot of journalists, I think I had a lot of American journalists, I had this kind of vague appreciation for the First Amendment. I knew it made kind of my job possible and my colleagues' jobs possible. And I knew it was a really good thing, but it wasn't really until I arrived in London, which does not have the First Amendment, that I began to kind of fully appreciate the importance of it. And the U.S. had the First Amendment, as you guys all know, not only creates this notion of a free press, but it also, through decades of Supreme Court precedent, has created a very clear legal framework that offers very specific protections, including against, at least in theory, against kind of frivolous and abusive defamation lawsuits. And so I arrived in London not really having thought very thoroughly about any of this, and quickly was bombarded with legal threats and occasional lawsuits and even injunctions by powerful people, rich people, or just litigious people who wanted to stop reporting that I was doing or that my colleagues were doing. And my initial reaction to that was this is ridiculous. This is a free country. It's democracy. This obviously cannot stand. And I was quickly disabused of that notion because the UK does not have the First Amendment. And a lot of our reporting got shut down, or at least nearly derailed by again legal threats and actual legal actions taken, whether it's by a company or a Russian oligarch, or in some cases the British government itself, which would go to court occasionally to try to get court injunctions, court orders to stop us from publishing stories. And so I lived in London for 6 or 7 years and returned back. It was a little more than 6 years, because I returned back right before the 2016 presidential election, and was kind of excited to be back in the US, where press freedoms are real. And quickly realized that a lot of the tactics that I'd been encountering in the UK seemed, in the intervening 6 years in which I'd been gone, some of them had kind of arrived and become increasingly popular in the US as well. And so there's become this very robust kind of niche legal industry that specializes in threatening and suing journalists, often using, and I'm sure many of you guys have experienced this yourselves, but like using fairly belligerent pre-publication legal threat letters to try to scare you away from writing, or at least water down what you're doing. And so I was just kind of noticing this gradually, and working first at the Wall Street Journal, and then in 2017 I moved over to the New York Times, and both of those institutions are like quite well equipped, at least relatively speaking, to deal with these kinds of situations, because we have, at the Times, we have a like really, really kind of top of the class group of in-house lawyers that specialize in dealing with this kind of stuff. We have, relatively speaking, a lot of money, and we have an ownership structure that is deeply committed to kind of independent and accountability journalism. But by like 2022 or so, we were getting, my colleagues and I were just getting so inundated with these legal threats that it was really becoming, wasn't a problem, but it was like really inconveniencing us and slowing us down a lot. And it occurred to me at one point, while we were kind of wading through this morass trying to get a story published and like going back and forth with these lawyers over and over again, uh, what would this experience be like if I didn't have the privilege of working at the New York Times? And or to be more specific, what would it be like if I worked at a local news outlet, or if I was like one of the hundreds or thousands of journalists who have started like Substack newsletters or YouTube channels or podcasts or whatever, and didn't have the institutional backing of a place like the New York Times or the Wall Street Journal. And so I think in early 2023, I started calling around to actually a lot of press associations all over the country. I think I reached out to press associations in, I don't know if it was in all 50 states or covering all 50 states. And Linda, I think maybe, did I reach out to you? I might have. Basically just asking like what people were seeing in this space, and whether they were receiving legal threats, whether they were aware of cases that were kind of abusing uh, the law here to try and shut down legitimate journalism. And I just started hearing like horror story after horror story all over the country. And it was, it ranged from uh, company or individual that we're writing about is harassing us with legal letters, and that's making it harder to publish. That was kind of like on one end of the spectrum. On the other end of the spectrum was we got sued, and the case ultimately got thrown out, but the amount of money and time that we had to devote to getting the case thrown out was so great that it drove us out of business, or it like pushed the reporter past kind of the psychological brink, and they ended up being hospitalized for panic attacks and ended up leaving journalism altogether. And I heard more stories like that than I can recount, and really just thought that this is not something that was receiving the attention that I believed that it deserved. And so I started kind of looking into this more and compiling these stories, spending a lot of time speaking with and just being with local and independent journalists around the country. And I pitched it as a book, and my editor, who was a little bit skeptical of this idea as a book because he didn't think that anyone wanted to read a book about journalists, which is, you know, fair. He asked a really good question, which somehow had not occurred to me, which was that the U.S. prides itself on having these robust legal protections and constitutional protections for journalists. How on earth is it that we're seeing these threats, and these threats are becoming so effective, notwithstanding those legal protections? And so I started digging a little bit into this. And again, I'm kind of embarrassed. Well, I've actually long since ceased being embarrassed, but I was initially a little bit embarrassed that I knew New York Times versus Sullivan. I was aware of its existence. If you had like asked me to define what New York Times versus Sullivan was, I probably would have said it like makes it harder for media companies or journalists to get sued. And that would have been about the extent of it. But I really started digging into what New York Times versus Sullivan was, the history of it, and the implications that it and some subsequent Supreme Court rulings had for free speech, and in particular for kind of the evolution of the media in the United States. And as I started doing that, I realized this interesting coincidence, which was that a lot of the lawyers who were threatening or suing journalists and news organizations, whether it was at the New York Times or at, the Colorado Springs Gazette, or just some local person in LA who basically created like a newsletter. It was a lot of those same lawyers were also arguing with increasing success and savvy to get both the Supreme Court and lower courts, and in some cases state legislatures, to take steps to either overturn New York Times versus Sullivan or chip away at the protections that it offered. And realizing that there was this kind of nexus between these pretty overt efforts to muzzle journalists and this kind of behind the scenes legal campaign designed to really curtail the legal and constitutional protections for journalists, I realized that really was a story that had not been told. And my book publisher, was much happier about that. And so the book is kind of, I don't know if you guys have read it. I hope you will. But it really is this kind of, it's two things. It's one, it's this story about this attack on this kind of right-wing legal attack on New York Times versus Sullivan and the protections that it and subsequent decisions have established for journalists, interwoven with this very kind of wide-ranging assault on individual journalists and news outlets, especially smaller ones. I do not spend much time in the book talking about legal threats against places like the New York Times or the Wall Street Journal, or the CBS News or CNN or places like that, because those types of threats, in my opinion, are fairly manageable for the most part. And what's much less manageable, and in fact, what I think poses a really kind of almost existential threat to a lot of journalism around the country right now, are the threats and legal actions that are specifically targeted against smaller outlets and independent reporters, and that not in all cases, but in a lot of cases, are really designed to kind of destroy them essentially and drive them out of business. And anyway, so I started working on this in like late 2022, early 2023, and with the goal of publishing in early 2025. And well, maybe not obviously, at that point when I started working on this, it truly had not occurred to me that this book might be coming out right as Donald Trump began his second term and embarked on a really unprecedented assault on journalism and press freedoms and the First Amendment. And so, in some ways, the timing of the book in its publication is kind of serendipitous for me, at least, and for my happy publisher, because they've sold a lot of books. But it feels like timely. This whole issue feels like timely in a kind of terrifying way. And so, what we've seen in the past couple of months is, I'm telling you things you guys already know, I'm sure, but like there's been this very multifaceted and deliberate attempt by the White House, by Trump himself, and by his administration to do everything it can to make it harder for journalists to operate when they're criticizing people like him and his administration. That ranges from, attempting to dismantle Voice of America to kicking the AP, or trying to kick the AP out of the press pool when they will not refer to the Gulf of Mexico as the Gulf of America, to the lawsuits that Trump has filed against whether it's ABC News or CBS News or the Des Moines Register, to just the efforts of his administration, including the Federal Communications Commission, to use the leverage it has over broadcasters to try and essentially coerce them into towing the administration's line, whether it's on their personnel policies or on the way they're covering certain events. And and that's not even to mention the fact that Trump, seemingly certainly on a weekly basis, is going well above and beyond, I think, what any president has ever done in demonizing the media as an institution, demonizing specific news outlets, and in many cases demonizing like individual reporters by name. And that has consequences, and I think it's kind of dangerous. And I have a chapter in my book devoted to a situation which you guys probably have heard about, involving New Hampshire Public Radio and a reporter there named Lauren Shulgin, who wrote about, did an investigation of this guy named Eric Spofford, who was running a big network of rehab centers in New Hampshire and who was allegedly sexually abusing, I think in one case, allegedly raping. I might be getting that wrong actually, but engaging in sexual misconduct and other types of misconduct toward patients and staff. And Spofford, as is kind of like, used the same playbook, and in fact, the same lawyers that have been used in these cases all over the country. And but at the same time, some of his some thugs who with whom he was acquainted kind of also took matters into his own hand and physically attacked the homes of the reporter, the reporter's parents, the editor on the story, and those people have, I think, thankfully been arrested and convicted and sent to jail. But to me, it was a really clear reminder, if any was needed, that these threats it does not take much for these threats to spill from kind of the digital and legal realms into the physical realms. And uh, I certainly think that having the president of the United States engaging in that kind of rhetoric does nothing to discourage that and probably encourages it. So that's all I have to say. But I'm happy to take this in whatever direction you guys want. If you have questions or things you want to talk about, I'm at your disposal.
Would someone like to start? That was also interesting. Carolyn?
David, did you find, and I'm just about to go order your book. Did you find that some of these activities, particularly pre-publication, actually killed stories in a lot of cases? Did you find that important stuff was not getting out as a result
Yes.
of this, or was it more? Yeah. Okay. Yeah. Go ahead. And I'm wondering, is it? I mean, certainly, if you shut down or if you take them out of business, they can't do any more after that either. But I'm wondering about work that was maybe in progress.
Yeah, I mean, there's basically the way I had so many examples in this book, and I was cognizant, especially given my publisher's slight wariness about the commercial prospects of this project. I was like very deliberate in picking, not repeating myself over and over again. So I basically picked examples like of this stuff underway, that each example had to really serve a discrete purpose. And so the example in my book that speaks to this involves the Colorado Springs Gazette, which is like actually a very successful and kind of proud newspaper in Colorado that's won at least one, maybe two Pulitzer Prizes, and has a track record of having done really good local accountability journalism. And there was a reporter there and basically this whole trend toward weaponizing the legal system and defamation law against journalists it's been, there are examples of this, scattered examples going back decades, but it really has taken on a greater intensity since Trump came to power. And so there's an example with a reporter there named Conrad Swanson, who I believe in 2017 or maybe 2018 started reporting for the Gazette on this real estate development in town that was built on, it was a huge real estate development. It was built on top of basically the remnants of an old gold mining operation. And there he got a tip, or his editor, I think, got a tip from a homeowner in this new development that like foundations were cracking and kind of some of the streets were buckling and there was all sorts of damage happening to the property. And so he went and spent, I don't know, months, maybe a year investigating this, getting all sorts of documents, conducting dozens and dozens of interviews that basically found that the state and the city had not done enough testing to determine that it was safe to build a huge development on top of this kind of rickety old like network of mines and kind of the remnants of the mines, and that there were real concerns about, at worst case scenario, there's an earthquake and the entire thing like collapses on itself. And that was a worst case scenario, but there were other like more realistic scenarios that were also quite bad. And so he wrote a story about this for the Gazette. And then the owners of this real estate development, which was called Gold Hill Mesa, it was owned by a kind of a national real estate company. They hired lawyers at a big international law firm who started just threatening the Gazette and its publisher. And the Gazette in recent years was acquired by a kind of conservative billionaire, Phil Anschutz, who owns a bunch of other stuff in the Colorado Springs area. And the owners of this real estate development picked the law firm, big international law firm, that also happened to be representing the owner, the owner of the paper on some of his other kind of projects. And so yeah, the lawyers like literally marched into the office and started sending these threatening letters, which were really, it was just bogus. Like there was not, they were arguing that there were inaccuracies in the story and in kind of the future stories he was working on. None of that was really ever established. But in any case, like that is what New York Times versus Sullivan protects against. There's not legal basis to sue someone for defamation if you're a public figure, if what the reporter is writing is done in good faith, essentially. And there was a very clear track record after this happened, after these threats started coming in and the lawyers started visiting, that the paper's publisher started. It began with just like kind of the publisher of the paper got involved, which he hadn't previously done, and started kind of taking his red pen and cutting out paragraphs, sentences, and then it got worse, and they just started spiking stories altogether. And I ultimately saw some of the stories that were spiked, and you could make like judgments about, reasonable people can probably disagree on the merit of individual stories, but there's no question, no one disputes that the stories were spiked after this intervention by the publisher of the paper following these legal threats. And ultimately, the reporter, who was, is doing very good investigative work, quit the paper. And the paper at that point dropped its coverage of this real estate development, and in fact, reached a commercial agreement with the real estate developer that they would jointly promote stuff together. And yeah, so like definitely suboptimal. And I've heard many other, and I've reported out many other stories along those lines where in this case, it was, in my opinion, it was kind of a cowardly thing for the Gazette to do, and they kind of just took the easy way out. I think in other cases, it's like a little, I have some more sympathy for the news organizations that are folding, because given like the choice between sticking to your guns and continuing to pursue like a really litigious and rich or powerful person or company, or like fighting for the or managing to like maintain the kind of financial viability of your news outlet, that's not an easy choice. And it's like really easy for me to sit in the New York Times building in Midtown Manhattan and say, well, the journalism ethics say you shouldn't do that. And like these people are like actually like have employees and face a very real choice between being, like continuing to pursue a story and getting sued potentially out of existence, or like living to fight another day and picking a less litigious, less dangerous target. And the solution to that, in my mind, is having, I mean, aside from just like greater recognition of these issues, having stronger laws in above the state and federal level that discourage these types of legal tactics. But the truth is that like even anti-SLAPP laws, which I'm sure most of you guys know about, that are meant to really act as a deterrence mechanism, like even in the best case, when those are working as intended, they do nothing to deter the use of these pre-publication threat letters. And they make the pre-publication threats like a little less scary, maybe, but it doesn't, there's nothing, you still have to hire a lawyer. And that can take years. And especially for independent journalists, like, or even I think one mistake the journalism community has made in some of this in defending themselves is that this isn't even about, I mean, it is about journalism, but it's not just about journalism, right? If you're like a community activist and want to be speaking up and protesting like a real estate development, for example, like you were allowed to do that and protected in doing that by New York Times versus Sullivan. And it's the same protections apply to everyone, whether or not you're a journalist. So anyway. What else can I tell you guys?
Does anyone have any specific examples in New England that they would like to share that maybe, I mean, I know, I think most of us probably knew about the case in New Hampshire that's been going on. And as he said, I believe all the people now have been brought to justice in that case. But do people experience this, or I was wondering?
The interesting thing with the NHPR case is that, and that not only were the people who vandalized the journalists' homes convicted, the lawsuit that Eric Spofford had brought against NHPR was ultimately thrown out of court as well. But and that was another example of a case that, like, this litigation, even if you get it thrown out of court at a relatively early stage, you can still run up huge legal bills. And in this case, you not only run up the huge legal bills, but you run the risk that during the litigation process, during discovery, you are going to be required to hand over notes, story drafts, internal communications, external communications to either the opposing side or at least to the judge. And that's what happened in this NHPR case. And the plaintiffs, Eric Spofford, who is the one accused of all this wrongdoing, and it was accused of having a real history of threatening and intimidating witnesses and things like that, which he denied. But he and his lawyers were trying to get their hands on all of kind of like the raw materials from this reporting, which included like a lot of recorded conversations, because this was for a radio program and then for a podcast, as well as for like a traditional like news story. And obviously NHPR like very heartily resisted those efforts, but ultimately at the end of the day, the judge in the case, it was a state judge in New Hampshire, ruled that the simplest thing to do in a kind of adjudicating whether or not these things should be handed over was for him, the judge, to be able to look at all of the raw materials. And ultimately, the judge looked at all these raw materials and fairly quickly concluded that there was nothing in there to substantiate the claims that Eric Spofford was making. But it was still like a really, I know, in fact, having spent a lot of time talking to the reporters in this, like a really scary thing that they had to hand over their notes and other things to an outsider. And that was not the agreement that they had originally reached with their sources. It was not something that they felt at all comfortable with. And obviously, ultimately, you have to obey a court order or face the consequences. And so they obeyed. But it was, to me, that was like a really telling example of the cost of this litigation and these legal tactics, because it's not just about winning or losing in court. It's about the process. And I think one of the things I've seen over and over again is that that's by design by the plaintiffs. And whether it's Donald Trump or Eric Spofford or anyone in between, that they recognize that the prospect of years or even months of litigation and discovery and depositions and things like that it's really, really unpleasant. And I say that having been through some of it myself. And if you work at a place that is not like rolling in money, it can be kind of a matter of survival.
Right. What they can do.
I have a question about that. I'm Rachel. I'm a first year. Well, I just finished my first year of law school. And I'm going to be a legal fellow for the New England First Amendment Coalition this summer. But I also worked in the New York Times legal department for a couple of years from 2017 to 2019. So amazing,
Cool.
Amazing team of lawyers.
Yeah, no kidding.
In your corner. I'm curious, obviously litigation and discovery in particular is just like the costs are astronomical. I'm wondering, like, how often are these cases actually being litigated, especially when it's involving smaller papers? Like, are there a lot of settlements happening out of court, or like people really like, is it often going to court?
I mean, I think that's a good question. And I don't think I can answer it authoritatively, because so much of this stuff is threats and kind of saber rattling that occur pre-publication that are never come to public light. And I mean, sometimes it does come to public light, and I just by having like reached out to all these press associations all over the country and then ending up talking to a bunch of local media lawyers in many different states, like they had heard about or experienced a lot of these pre-publication threats. And so I was able to kind of track down a bunch of examples of that. But I think the vast majority of this stuff never comes to light. But I mean, there are kind of three different scenarios that like, or maybe not three. There's like a bunch of different scenarios that can play out. One is that like you send a bunch of pre-publication threats, and the news organization goes ahead and publishes anyway, and then you as a would-be plaintiff have the choice of whether to proceed with this in court and potentially subject not just the journalist but also yourself to discovery, or do you just like let it go? And I think probably most of the time they just let it go, because their leverage they were using was trying to either derail or like water down the story, and when that fails, their bluff is kind of called. And the purpose of actually filing the lawsuit is, I think, counteracted by the threat of discovery that you have to own up to. But I mean, there are a lot of these cases that do go to court, and it's interesting seeing them, because it's like they're just they're nowhere near meeting actual malice standard. It's like they should be thrown out like as early as possible. There's certainly a pattern in states without anti-slap laws, more of these suits do get filed, and they ultimately do get thrown out of court, but it sometimes can take, I mean, it can take a year maybe. And and then there's a whole appeal, and it's just like it drags on and on and on. There's a really interesting story which I tell in the book in Wisconsin involving a like a community news startup in I don't know how to pronounce it, Wausau, with a woman named Shireen Seward, who started this like community news outfit, I don't know, probably like 7 or 8 years ago now. And there was a community, like a town hall meeting, where a prominent local businessman referred to someone like with a homophobic slur in the meeting, and the news outlet ultimately wrote a story about that and identified the businessman who had used the slur. And the guy sued. First he threatened and tried to get them to retract it, then he sued. And I mean, it was true. Like, he uttered the word. There was like video. There were a bunch of people who were at the meeting who heard him say it. And like, but he sued anyway, and it just went through. I mean, the case got dismissed ultimately, and he appealed, and it got dismissed. The dismissal got upheld. But it was like huge amounts of money, and the community reaction. This is during, I think it was right after the pandemic, basically, and the community reaction to this lawsuit and this fight was really polarizing. And this community news website went from like, it was just not a partisan thing. They were just like covering the local news without an agenda or anything like that. And it immediately like polarized the community and led to like some huge number of their subscribers and advertisers backing out and canceling subscriptions or canceling ads, because this businessman had made this into like a fake news versus like standing up for the truth type of thing. And the lawsuit kind of course, like, he's free to say whatever he wants, but it was ended up being a fairly abusive lawsuit, I think. And I didn't talk to the businessman; he wouldn't talk to me, but I did talk to his lawyer at length, who was very open with me, I guess, to his credit, that the point of this was not, yes, they wanted to win in court, and yes, the guy wanted to clear his name, but by this point, this businessman had used in part the attention he was getting from this lawsuit to win election to the state legislature. And so clearly his reputation had not been severely harmed by this in the first place. But the lawyer was pretty candid with me that the point of this was, yes, it was to clear his name, but it was also to like basically like, get a pound of flesh out of this woman and this kind of upstart news site. And I think when you talk to some of these lawyers around the country, and occasionally you see this in discovery when these things actually do go to trial, you can see in the written communications that people have sometimes that the goal of the litigation is very punitive. I can't remember what your question was, though. I don't know if that answered it.
Yeah, no, I mean, that's really it just, how often things are actually getting litigated if, people are just dropping their,
Yeah. I don't think that settlements are that common, honestly.
Yeah.
I think I think there are some examples of that, and I detail one or two in the book where people are just like really left without a choice. And but I don't think the settlements are all that common. I think it's usually like the bluff gets called at the early stage and they're like, we're not going to litigate this, or it goes into litigation and ultimately, 9 times out of 10 probably is getting dismissed. But the price of that dismissal can be quite high, not just in terms, usually it's in terms of money and kind of distraction and things like that. But there's also a really, I think, pretty severe and underappreciated like mental health component of this, where some of the reporters who are and publishers in some cases, when it's kind of like a family operation, it's like I had a couple of people, and I again recount this in my book, who say that they were like became really suicidal. Actually, there's one guy who uh, began having such like debilitating panic attacks that he checked himself into a hospital and quit journalism. There's another guy who developed like a pretty severe alcohol abuse problem as a result of the stress of dealing with this. And again, these are cases that like under just, I think any mainstream like legal observer or lawyer would agree these are meritless cases. But that doesn't prevent them from exacting a really severe toll on the people involved.
Anyone else have any questions before we're certainly open? I mean, I thought it was a fascinating topic myself, and it makes me want to read the book, especially in light of what I was telling you before we started the meeting about our First Amendment collaborative and trying to get a handle and gather the stories just within New England and offer a place for journalists and publications to be able to turn, not that we would be able to help them in the legal sense with money, but that's also potentially a goal that somehow we might be able to help in that area in the future. But at least be able to provide resources for them to navigate the time that they're going through and make the decisions based on, facts and research, outcomes and things that have been documented like you did.
Yeah. I've done quite a few like meetings with like other journalists and groups that are interested in protecting journalism. And I often get the question, it's like, well, what can we do about this? And we talked about anti-SLAPP laws earlier. I think generally you can like raise awareness, but to me, like the single most effective thing that journalists and their lawyers can do, other than just like practicing the craft fairly and ethically and responsibly, which I think hopefully goes without saying, because if you're doing your job well and you're doing it in good faith, like ultimately the law is very much on your side. But just like one practical thing that I like to tell people, and it is a little bit self-interested, so maybe take it with a grain of salt, but I think the act of when you're getting threatened and it's garbage, the act of bringing those threats to public light is really effective. And whether it means like leaking it to a journalist or like posting it on Instagram or whatever and saying, I'm getting threatened for this article, there's like, I don't think these lawyers feel a whole lot of shame in what they're doing, making these threats. And oftentimes their clients don't either. But generally the reason these lawsuits get filed is because someone feels that they don't like what you've written. And the one antidote to that, in my limited experience with this, is, well, if you don't like what you've written, you probably don't want more publicity about the fact that you are using really heavy-handed legal tactics to scare us into submission, because that makes it seem like you're hiding something else and that you're a bully. And so again, it's a little self-interested because I love nothing more than like retweeting these screenshots of angry lawyer letters or writing about them myself. But I do think that is like, it often works. And I've seen on multiple occasions people back down after their threatening tactics come to light. So,
David, are news outlets covering the threats themselves? The ones who are threatened, are they covering it themselves?
Some are.
Yeah.
Well,
Self-serving.
it's a little, it's tricky. I mean, I think the thing I've seen more of, sometimes the news outlets themselves are covering it. other times that, I mean, like my book came out in like March, I think, or yeah, March. So like 2 or 3 months ago. And the number of like inbound phone calls and emails and signal messages I've gotten over the past 2 or 3 months from journalists who are in this exact situation and are looking to kind of quietly find or strategize about a way to bring this stuff to public light. It's like I've received a lot of inbounds, and I think like occasionally the news organization themselves will write about the threats. I think it's more common though to see a third party write about them just because it creates a little bit of distance. I mean, this is just one random example that pops to my mind, but there was a book that a colleague of mine wrote a few years ago now on a big hedge fund guy who has some like weird business practices. His name is Ray Dalio. And he hired this law firm, Clare Locke, which is at the center of my book and has its own like sordid history. He hired Clare Locke to send a bunch of threatening letters to his book publisher. And someone, I'm guessing it was my colleague, but I don't know that for sure, someone leaked all of these threatening letters to the New York Post, which then wrote a whole bunch of stories about how this law firm and this hedge fund guy were trying to shut down a publication of a book, which, first of all, I'm not certain on all the details about exactly what transpired, but I certainly know that from the perspective of the author and the author's publisher, having that kind of publicity did nothing but drive sales of the book. And I think I don't know how people at Clare Locke or at this hedge fund, whether and how they kind of reflected on how that strategy played out for them. But like objectively, I think it didn't play out that well, it seems like, because it led to more publicity about the thing they were trying to shut down in the first place. And I think that if a journalist or a lawyer for a journalist feels like these threats are bogus and are really abusive, sometimes they're not, by the way. Like that's another thing worth keeping in mind. Like a lot of times we get kind of threatening letters on behalf of a client that are really, I mean, they are threats, but they also contain lots of useful information, and they're, like in the reporting process, sometimes we go to seek comment from someone or check our facts, and we don't have our facts right. Or like they say something in their comment that changes the way we're considering a story, and sometimes fundamentally. And that I think it's important to differentiate between communication like that maybe you don't want to hear, but that is actually like constructive and important, because we do as journalists get things wrong, and sometimes our theories are wrong, and sometimes we've misunderstood something, or a source has led us astray, or like we've misinterpreted something. And so I think it's like, just because the communication is coming from a lawyer does not, to me, intrinsically make it bad or threatening or anything like that. But there are definitely like many cases where it's just a pure threat because they don't like what you're writing about, and they're trying to kind of scare you away from it or impugn your reputation with your employer or your publisher. And it's those situations that I find a lot more problematic.
If I could
Anyone?
ask one more legal
course.
question.
Sure.
I haven't read the book, but I did read the piece in the magazine. And I'm really curious to hear a little bit more from your perspective about Sullivan and the future of it in this Supreme Court. Because I think, I've heard some mixed things about it. I
Yeah.
have my own thoughts after, just 1 year of law school, but obviously this particular court has, made clear that they're pretty comfortable overturning precedent on very precarious legal grounds.
Yeah.
So I'm curious to hear a little bit more about that.
Yeah. I mean, so they're just like the backstory here is that there are two justices, Thomas and Gorsuch, who have both publicly expressed, at the very least, an interest in reconsidering Sullivan, if not overturning it outright. You need, and Rachel, I know I'm telling you things you already know, but you need 4 votes to accept a case for review, and obviously 5 votes, a majority, to actually change, to form a majority and, change precedent. And I don't know if there are another 2 or 3 votes to overturn Sullivan. In fact, this is a subject of some disagreement among myself and my colleagues and even our lawyers at the New York Times, who all think that I am maybe a little too paranoid about this. I may be. I think that there are some recent cases where a majority of the court has used the logic behind Sullivan to rule on other cases, which has sent a message to a lot of people in the First Amendment community that Sullivan is safe for now. And it may be. I guess the counter argument to that is that we don't know where Alito stands on this. We don't know where Barrett stands on this. We don't really know where Kavanaugh or even Roberts stands on this. And Kagan herself has like written critically about Sullivan in the past, long before she became a judge. But I guess if I were going to make a prediction, it would be that the court does not, in the near term, overturn Sullivan or even take a case that would push for overturning Sullivan, but that it's much more likely that there is a case that the court takes where they're looking at kind of narrowing the scope of Sullivan and kind of chipping away at it around the edges a little bit. And I think there's kind of at least two ways they could do that. One is you could the court could basically argue that more of the stuff needs to get before a jury and shouldn't be dismissed at such an early stage, that like the actual malice standard should basically be should be up to the jury, not up to a judge. The other thing that I think is more likely, though, is that you narrow the kind of the scope of who is classified as a public figure. And in the Sullivan decision itself, I'm sure I'm telling you guys all things you already know, but in the Sullivan decision in 1964, it applied only to public officials, so like elected leaders, things like that. And then there were a couple of subsequent decisions that broadened that to include public figures, and then public figures who were in some cases not even deliberately seeking the spotlight themselves, but were like an air traffic controller who was on duty when a plane crashes, for example. And so under the current precedent, people like that, to win a defamation case, need to show that the publisher either was lying or should have known that they were producing or presenting false information. So it's a much higher bar. And I think it's possible that the court could take some steps to shrink that circle a little bit. And there have been some cases in the past that might have, like 20 years ago or so, that might have been good candidates for that. But at the time, that was not where kind of the zeitgeist was. And I spent a chapter early in the book telling the story about this female fighter pilot in the Navy, who was one of the first female fighter pilots in U.S. military, whose career got completely derailed because of a report questioning her qualifications by a conservative advocacy group. And she sued for defamation. There's no question that her career had been destroyed as a result of this report. And there's no question that some of the information in the report was, like, at best lacking context, if not outright wrong. And the fighter pilot, Carrie Lorenz, lost the case in part because she was classified as a public figure, and because she was, had been thrust into this spotlight, and the media or the military, the Pentagon, was using her as kind of an emblem of their newfound like progressivism after the tailhook scandal in the 90s. And so her case was thrown out on Sullivan grounds, essentially. And I think if a case like that today were to make its way up to the Supreme Court, it would have a much more receptive audience than it did back in the early 2000s when it was appealed to the Supreme Court and the appeal was rejected. And it depends kind of on it depends on the scope of what the Supreme Court would do in a situation like that to determine how problematic I think it would be. I mean, I think there's a world in which someone like Carrie Lorenz, who really did nothing to seek out the spotlight, her having her career destroyed by a slightly faulty report is not fair to Carrie Lorenz. And it's like, yeah, it's just not good. On the other hand, you can see why you want to protect the right of anyone, whether it's a conservative advocacy group or the New York Times, to aggressively question and report on Pentagon policies. But I mean, I think it would just have to depend on what the court does there to see if it really makes a huge difference or not. But I definitely think that in general, narrowing the public figure definition And it could be very problematic because there's so much stuff that the media writes about these days that it does not involve government officials. It involves people who hold sway over society in many other ways. And, you know, if we risk getting sued by writing about them, yeah, that's just not great.
Okay, well, we're almost at our time, so.
Eric, can I throw in one more quick
Sure,
question
of
before we
course,
lose
of course.
David? David, I've got to put on my my university advisor hat for a minute. And did you find any examples of student or campus newspapers where that were threatened? And it's interesting because their sort of maybe main focus of investigation or coverage might be the administration. And I don't know if any universities sue their student paper, but they also might write about an outside business owner or something.
Yeah, that's a good question. I don't think I did. I'm trying to rack my brain. I don't think I did hear about anything like that. And it's funny, as I said earlier, I've done a lot of speaking events since the book came out for journalism groups and also journalism schools. And so I've been like on campus a bit, especially in the New York area. And I was like up at Columbia actually probably a month and a half ago, and with talking to a bunch of journalism students, and a couple of them, and obviously I wrote the book primarily before the Trump administration, or before Trump even won the election. And I think there, all of a sudden, the threats to campus, let's say the student journalists, has like really ratcheted much, much higher. And it's one of those things, if I had known where the world was going when I was reporting and writing this book, there's some things I certainly would have chosen a little bit differently. And probably looking at student newspapers is quite possibly one of those.
It really wasn't. It wasn't your next book. It's okay.
Yeah, probably not. My publisher is definitely does not want another journalism book right now.
Okay. So. I might hit you up to Zoom in for my class if that's okay.
Yeah, let's talk about it. You're
awesome.
Welcome to suggest it.
Well, thank everyone for joining us today. And thank you, David. This was really interesting. And it does make me also want to go out and get the book and read through all of the examples, just as a background for what we're doing now. And, you know, it'd be a good formative thing for me. So yeah, please join us for our next NENPA University presentation. It's not an editorial presentation, but it's more along the advertising lines, how to make a media kit that sells in 2025. So I'm not sure we have the right audience for that here now, but I feel beholding to say that. And if anyone has any questions, I will send out the recording of this, and please share it with anyone that couldn't be here. And if you have any questions, just let us know.